In the next in our series on quick introductions to the main intellectual property rights, we're now looking at patents, or patents if you prefer. There is no special magic about how you pronounce the word, but people who work in the industry tend to say patents for no, I think just to distinguish from patent leather shoes, to be honest. So what is a patent? Well, it's basically a state-registered monopoly given to inventors for their invention in return for the inventor providing full details about what their invention is, how it's useful, and how it works. The process of acquiring a patent demands that the invention has to be something new, so something novel that hasn't been produced before. It doesn't have to be fundamentally new. It can be an incremental benefit or new thing based on existing knowledge or inventions, but it still has to include something that is definitively new. The second thing is that it has to be innovative or have some kind of inventive step. So there has to be some subjective way of describing what you've done that demonstrates you've put some effort in and you've solved a problem in a new or innovative way. And as I say, that is a subjective review, but an awful lot of background information is assessed in order to understand, is this just an obvious incremental change you made, or have you done something specific and creative? The third thing is that it has to be capable in practice of being put into place and being used. So for example, the classic example of something that you couldn't patent would be a perpetual motion machine, because that would require the laws of physics to be different to what they are, so you can't patent something that is effectively impossible. Interestingly, you could, in theory, patent a time machine, provided that you only promised that it went back in time, because according to Stephen Hawking, in theory, that's possible. Going forward in time, you wouldn't be able to patent. So what's the benefit of having a patent? Well, it gives you a period of time, depending on your registration, between 15 and 20 years, within which you are the exclusive owner of that invention in the jurisdiction of the patent. You can't get a patent that applies globally. You would have to register it in different countries. Now, if this invention is useful to people in industry who either compete with you or work in an area where the patent has come from, then they would have to pay you a license fee in order to use your invention in their products and services. And that's why if you patent a piece of technology you've invented, it can become a royalty earning or income earning device. Equally, if you want to be the only person that can produce a particular product or service which relies on that patent, then you can exclude everybody else from the market, and you can be the only provider of that technology for the period of time that you have the patent.